Never in a million years have I ever felt as vulnerable and helpless, insecure, and sad as I was when the Department of Children and Family Services removed my child from our home for perceived allegations which were untrue. And then 5 months later, my child is removed from me. I didn't know what to do. I was stabbed in the heart, picked up the phone book, found the biggest ad, saw the law offices of Vincent W. Davis, and I called. And I immediately felt very comfortable. Gave me my options, told me what I could and could not do. And then I met Vincent Davis, and I was so impressed.
All right, good morning. Today's live stream is how to build a winning CPS defense strategy from day one. Welcome to my office hours. I'm attorney Vince Davis, and today we're tackling one of the most important topics you'll ever hear or think about if you have a CPS case. How to build a winning CPS defense strategy from day one. If you're under CPS investigation, or if you know someone who is, your defense starts immediately, not later. Today, I'll show you how to fight CPS, how to fight a smart and build a strong strategy proactively, and I'll help you avoid the common traps that most families and most parents fall into. If you find this helpful, please consider donating or joining my Fight CPS School, SKOOL.com. So let's just get started. The first thing that I want to mention is your mindset for a CPS defense. You have to understand you are under investigation by a governmental agency. The second thing is you have to assume everything you say or do is evidence that will be used against you. Your mindset has to be one of calmness, focused, organized. I see so many people become desperate, excited, and willing to do anything, thinking that they're going to get their child back. Next, view the social worker as an investigator, as a policeman, not a helper. And you should build your own defense team early. Your attorney, your therapist, maybe your own social worker, and of course, that ever important family support. The next major theme is you must immediately first steps after CPS contact. Immediate first steps after CPS contact. Number one, politely refuse interviews until you have an attorney. Please, please, please understand that piece of advice. So many of you that I talk to decide that you're smarter than the social worker, decide that the social worker is your friend, and that you will talk to the social worker. Request everything from the social worker in writing. 95% or more of people today have smartphones. Text, email with the social worker. Don't talk to the social worker. If you can, if it's allowed by law, or if you inform the social worker, record all your interactions with the social worker. Again, everybody has a smartphone. You can buy that free app or download that free app that will record all phone calls that will record all interactions between you and another person. Be mindful of the laws in your state about recording someone that where they don't know that they're being recorded. You know, there's one-party states, two-party states, no-party states. And in my state, California, both people have to know they're being recorded for you to be able to use that evidence. In California, the law is very strict. If the social worker doesn't know they're being recorded, you can't use that evidence anywhere at any time. There are a few exceptions to that rule, but what I suggest is you inform the social worker that they are being recorded, and if the social worker says, I don't agree to being recorded, then you tell the social worker, we're not having a conversation until I speak to my attorney. It's simple as that. And if they threaten you with taking your child, that will be recorded because you've already told them you're recording. And that may be used against them in a subsequent civil rights case. Next, ask if they have a court order or emergency authority before allowing entry into your home or apartment. And you must identify potential relative placements for the children early. In California, and maybe in most states, there has been a recent change in the law. Non-related family members, in other words, AKA family friends, and relatives may be on the same level. So if you don't have family close, get a family friend who's close, a coworker, a church member, someone you belong to a social club with. But it's important that you get the child placed with a family member or non-related person as soon as possible. Having the child in a family friend's home or family or friend's home is tantamount to you being released from jail on a criminal charge out on bond. Here's the key quote and the pro tip. Delay and unpreparedness lose cases. Action and preparation win them. The next step is building your evidence. Start documenting everything immediately. Collect medical records, school and attendance records, photos of your safe home environment, clean drug tests, proactive, not reactive. Get letters of character from teachers, clergies, doctors, family, friends. Create a timeline for every CPS interaction. Pro tip, organized parents win cases. Disorganized parents struggle and make it harder for their attorney to win the case. The next segment is understanding the legal framework. You have to learn the basic courtroom structure and the names of the hearings. Remember, there's the detention hearing, which I call Module 1, the jurisdictional hearing, which I call Module 2, the dispositional hearing, which I call Module 3, the review hearings, 6, 12, and 18-month review hearings, and then finally, the 366.26 hearing, the selection implementation hearing, which I call Module 5 or 6. You have to understand these modules. You have to understand the framework of the juvenile dependency process. I wrote a book, seems like 6 or 7 years ago. It's called The Secret, How to Fight CPS and Win. Interestingly enough, it is sold on Amazon, and every time it's sold, I get a check for, I think, 25 cents. So since I make so little from that book, I give the book away. So you can call my office and request a digital copy of the book, or if you see any of my ads or my YouTube channel, you can find the book and download it. If you want a hard copy or a digital copy, just call my office, 888-888-6582. Give them your name, give them your email address, and give them your text, because a lot of times I can just text you the book. It's in digital format as well. Next, you must know what CPS must prove. At the detention hearing and at the jurisdictional hearing, they must prove by a preponderance of evidence, which is in California the lowest standard of evidence there is, more than 50%. So it's hard to win the jurisdictional hearing unless you're prepared and your lawyer is prepared and your lawyer is experienced. There's another level of evidentiary burden, and it's called the clear and convincing evidence that the social worker must prove at the disposition hearing and the selection and implementation hearing. Very important. Clear and convincing evidence means, in my opinion, 75% or more. Harder for the social worker to prove at those hearings. Keep in mind that federal and state protections should be applied and argued by your lawyer. There's the Fourth Amendment illegal search and removal issues, and there's the 14th Amendment due process rights issues. There's a case that I would recommend that everyone read. You can Google it. So the name of the case is Wallace versus Spencer. Wallis v. Spencer, Spencer. It's an older case from the Ninth Circuit Court of Appeals, the federal court, and it talks about some very important due process rights that are yours and that the social worker must not violate during a CPS case. Next, there are defense strategies that I have found that work time and time again. Number one, file motions early. Motions to dismiss, motions to challenge the veracity, motions for discovery. The discovery can be all important. A lot of people, attorneys, don't even think about asking for the discovery. And sometimes the discovery, the informal discovery, has the most evidence that could help your case. Next, challenge the jurisdictional allegations line by line. Proactively offer a case plan if services are needed, or if you think the judge may think that they are needed. Nothing like starting that parenting class before your jurisdictional hearing. Nothing like starting sometimes drug testing or anger management or individual therapy before the jurisdictional hearing. It is not an admission of guilt, and it could buy you the important credits that you need in your case. Use experts. I have a couple friends who are attorneys in this area. That's their secret weapon, the use of experts. Psychological evaluations, substance abuse counselors. Even there are experts that can opine on whether you are sexually abusing a child. Next, always challenge evidence and social worker credibility where appropriate. Now, this comes up many times for me, and you should be discussing this particular strategy with your lawyer. How are you going to discredit the social worker? Sometimes it's easy to do. Sometimes it's very difficult to do. But these are things that you should be taking a part in while your case is moving on, from hearing to hearing. This is important. Always act as though every appearance is a trial, because in the judge's mind, it often is. All right, the next segment is mistakes that kill CPS defenses. So pay attention and don't do these things. Number one, missing hearings. Don't miss any hearings. Number two, failing court-ordered drug tests. Sometimes a little easier said than done, but the judge is watching. Number three, posting negatively about CPS on social media. This will get you such special attention that sometimes I get the feeling that the social worker and or the judge bend over backwards to teach you a lesson. Stay away from that. The next thing that can upset your defense is threatening or confronting social workers. This will definitely get you negative credits with the social workers and with the courts. Don't do it. Next thing is you shouldn't ignore the child's lawyer or the CASA volunteer. Now, you don't have to talk to them without me being present, but let's not ignore them. All right? People that my grandmother used to tell me, who raised me, you get more bees with honey. So keep that in mind. People are the same way. Here's a key and a pro tip. Even if you're angry, act professional at all times. The judge is judging your behavior, your demeanor, not just your evidence. The judge is watching you and determining what type of person you are. Same can be said for a lot of social workers. Social workers are governmental employees, right? They're not doing the job for money. So why do people become social worker or government employees? You have to assume that they want some type of respect in life. And it's your job to make sure you give them that respect so that they don't try to work against you. Now, I know a lot of you are going to be upset. I know a lot of you are going to don't like that advice. But after almost 40 years of being a lawyer, I'm telling you what my experience tells me. Your job is to try to win the case and try to get the children back in your home. If you're really upset with the social worker, after you get the children back, consider suing the social worker. My grandmother always used to tell me, don't get mad, get even. If you build your CPS defense strategy from day one with the right mindsets, documents, legal knowledge, and team, you drastically increase your chances of success. Remember, you don't have to fight alone. Join my Fight CPS school. It's just $10 a month and it gives you webinars, templates, and weekly coaching. And if this live stream has helped you at all today, please consider donating to this live stream. This information is vital and it's free for others. Please help us keep it going. I'm Attorney Vince Davis. Stay strong, stay prepared, and I'll see you next time on CPS Office Hours tomorrow at 6:30. Although tomorrow's show may be delayed, I have to drive a couple of hours to a CPS trial tomorrow. So I may not be on at 6:30. It may be later in the day. All right. I had a guest scheduled to come on. I spoke to her last night. It's early Sunday morning. She has 7 children, so maybe she's not able to call in or join us on this login right now. But I will take some questions from the audience. Let me go to the questions. All right. Tina Smith, watching us on YouTube. So impressed with what I paid to talk to him and have a conversation. He gave me 5 minutes of his time. I thought he was right guy, but it was so sad he pretty much took my money. Tina, I apologize if you feel that way. Please call me at 888-888-6582 and we can continue your conversation. Although I do wonder why you're on the show if you think I'm not giving out good advice. All right, next we have Christina Reyes from Facebook. I didn't know roommate had a recording device. Meanwhile, CPS supervisor says my kids never said anything about abuse. I say, yes, they told the police and the doctor about abuse, and it's stated on paper I got from court. How foul is the supervisor now has retired. Vegas in court the day. Police on the stand say my daughter drew lines from breast, etc. We had never been in court. Court prior, he had the children sitting with him outside, is allowed to take the kids home. Okay, Christina, I'm sorry, I don't understand the question you're trying to ask. Maybe you can try to retype it or call me later, 888-888-6582, and we can address your question privately. Erica McDonald from YouTube. Did you get a chance to look at the paperwork tonight? I texted you yesterday. Is there anything that I can do to have my lawyer file something? Erica, I did look at the paperwork. You know, there are a lot of things that you can do to try to suggest or push your lawyer into filing things, but you can't make them. And sometimes, you know, in these situations, what I've seen is lawyers take the exact opposite. The more you push them, the less they want to do for you. Why that phenomenon exists, I can't tell you. If you want some more detailed discussion about that, Erica, give me a call, 888-888-6582, and I'll try to give you some other suggestions that might work in your situation. The Minecraft team, thanks. Margaret King, a member of our YouTube membership. Good morning, Mr. Davis. Safe travels to your meeting. Have a blessed day. Oh, Margaret, I'm not going to a meeting. I'm going to a trial tomorrow in a CPS case that's about 2 hours away from my office. So thank you for the safe travels. Erica McDonald from YouTube. They have a program in Orange County that for women and children substance abuse, if they have a CPS case, and I would like to go to that program, they have room for me, but I asked my lawyer and she said, okay, Erica, she said, you leaving me hanging. Oh, she said, want me to do drug treatment program. I'm doing one. I relapsed during pregnancy. So because of my medication, and I'm on my way on my medication now and doing what I got to do. Okay, good. I'm glad to hear that, Erica. I'm not sure that there's a question there in that comment, but thank you. Okay, Annie from Wisconsin on YouTube. If I admit myself to a psychiatric hospital, will it be held against me? That's a good question. And I have to be honest with you, in this particular case, probably. I don't know if you can admit yourself into the hospital without them knowing. And technically, because of HIPAA rules, they're not supposed to be able to learn it or use it against you. But if you think you need to go to the hospital, especially a psychiatric hospital, I would go. Your health is important. Margaret King, a member of YouTube and on YouTube, says, I am curious about a hair follicle test. A hair follicle test is the root of the hair strand. Why do they just not strip the strands of the hair and not from the root? You know, I can't really tell you, Margaret. I'm not a drug testing expert. Once in a while, we have private seminars where we have an expert who happens to be an attorney, but is also an expert in drug testing and pharmaceuticals. And his name is Okori Okorocha. We call him Double O. It's spelled just like it sounds, Okori Okorocha. Google that name. You can find him. and give him a call or email. He may answer that question for you. Neri from Facebook says, "Good morning, Mr. Davis." Good morning, Neri. Erica, oh no, Justice Mia Love Ganza from YouTube. Will the mother you won the case will come on the show? Justice, I'm checking my texts. I spoke to her last night at about, let's see, 10:30 p.m. We didn't speak, we text. And she said, "Good morning, good evening. Yes, I will be on the show. Email me the link to be on the show, my Justice." So if she decides, I'll tell you what, if she wakes, she's a mother, she's got 7 kids, and it's a Sunday morning. So maybe she got other important things to do. But if I hear from her today, I'll come back online just to bring her onto the show and, go live online, and it'll be recorded. So hopefully you'll be able to see her and hear what she has to say. And if you catch the show live, if you get a notification on YouTube, you jump on and ask her questions if you'd like. Christina from Facebook says, "Thank you." Erica McDonald says from YouTube, "I did the same thing. I called the CAT team and had to go to the mental hospital because I couldn't get my psychiatrist to prescribe my medication." Erica, you should be working closely with your doctors, perhaps seek a second opinion. Kimberly from YouTube, Kimberly Eshman, good morning. Good morning, Kimberly. Margaret, the hair follicle testing is a complete scam and money-making fraud. You might be right. I want to tell you something. In the juvenile dependency area, the CPS area, and even in the family law system, hair follicle tests are treated as if they are the golden standard. I always thought that until I did a seminar, and one of my speakers was Corey Okorocha, 00, and he told me and told everyone at that seminar, hair follicles are not the golden standard. As a matter of fact, they're one of the most unreliable testing methods. And I was kind of surprised. And I told that recently to a judge who looked at me, and that judge just shook their head like, "Davis, you don't know what you're talking about." Here's what the expert told me. Because your hair is susceptible to things in the air, and you walk out on the street, you're around people in closed rooms, you're in public areas, your hair is picking up a lot of substances. Hence, that's why we wash our hair, right? So often. Why? Because it gets dirty and filled with substances that are just in our environment. Because of that, hair follicle testing from a scientific point of view is unreliable. I recently spoke to a client, or a potential client, who had this very problem. She was testing clean in urinalysis and even tested clean from a blood draw, but her hair follicle was coming back dirty with small amounts of illegal drugs. Now, that's almost impossible for you to test negatively in your blood draw because that's completely closed off, and then test positive with your hair follicle. Obviously, your hair is susceptible to picking up things in the environment. And because she tested positive hair follicle, even though she tested clean blood draw and urinalysis, she has lost her child. And one of the reasons why she lost her child goes back to when my earlier discussion, using experts. That is a case where you would want an expert to come in and educate the judge, educate the social worker as to why your hair can be positive, but your blood is negative and your analysis is negative. There's only one explanation, right? The environment that you're walking around in. And you have no control when you're on the bus or walking down the street or in a closed room or at the grocery store, who you're around and what they've been doing. You have no idea. All right, Eric on YouTube says, no, she has spoke to the other attorneys and they wanted me to wait for my social worker to respond to me. And she said I wasn't at that stage yet to go to that program. Well, Erica, I don't know what to tell you. You need to be talking to your attorney, coming up with a strategy and a plan. Okay. I appreciate that you're watching my show and you're asking my questions. But remember, I haven't seen your file, your medical chart, so to speak. I don't know what exactly is going on except for these intermittent questions you ask me. You're going to have to speak to someone who's an expert with your file, with your evidence, and come up with a plan and strategy. All right. I can do that for you, Erica, but I can't do it on a live show, a live stream that lasts, 30 minutes. All right. Kimberly on YouTube. I think she's referring to hair follicles. Because of damaged hair leaches out the deposits. So new hair is needed. Plus, they are looking for recent use. This would be a new growth. Okay. Annie from Wisconsin says, thanks. Kimberly also says, I'm no professional, but I've had to take many of them. I guess you mean hair follicles. Margaret from YouTube says, thank you, Kimberly. I didn't understand why my drug test came back negative for everything else, positive for codeine, and I never took codeine in my life. I did request a reanalysis or retest. I don't know if you know, folks, that you know this. It's federal law. Anytime you take a drug test for any reason, especially at court, and you don't like the result, you're entitled by law to a second test, a retest of that same sample. And if they don't retest you, I think there's some legal authority says they can't use the first test against you. If you try to pull that in CPS court, they're going to look at you like you're from Mars, that you're some foreign alien. Like, what are you talking about? But it's in almost every contract the county has with drug testing facilities, or the state has, because retests are so important. Do you know why? Because scientific tests like drug tests are not 100% accurate. There's always a margin of error of plus or minus perhaps 5%. So you could lose your child on a mistaken false test or a mistaken positive test. Justice from YouTube. Is the blood test the best option? According to expert Okori Okorocha, yes. The problem is CPS doesn't spend the money for blood tests. They're too expensive. That's why they try to get you with the drug patch, which is highly, highly unreliable. And then, of course, the urinalysis. But make sure when you do the urinalysis test that it's a drug test, not a drug screen, which is a lot cheaper. And drug screens, in my opinion, are not admissible into evidence. But they use it all the time to take your children and to keep your children away from you. Talk to your lawyer about whether drug screens are admissible in your state. All right. Christina from Facebook says Tish Wilson. Okay, I guess you must be calling or putting something out there for Tish. Let me see, looking at some other questions. All right, Margaret says, my blood test and your analysis all came back negative. That's what I'm feeling. They're going to use the negative hair follicle against me. You mean the positive hair follicle against you? Yes. you might have to get an expert or you might have to retest. Margaret also says, we'll see what happens with the retest. They're just going to send out the old specimen to the independent lab. Yes, that's how they're supposed to do the retest. Justice says, can the children from the families you have won and rescues come to the shows also, please? Justice, yes, I will be asking people, even if it's been years, please. Yes, it would be good for us going through this. Absolutely, I agree with you. Let me tell you a couple problems with that. Sometimes people don't want to come on. Sometimes people don't want to share with the public and, a billion people on social media what they've been through. And sometimes, I get people to agree to come on, like my client this morning. And it's Sunday morning. I confirmed with her last night at 10:30 p.m. But, she's a mother of 7 on Sunday morning. Maybe things have come up. All right. Let me see what other questions are. Justice says, get an expert. Oh, Justice says, can the children from families you have won and rescued come on the shows also? Justice, I can only invite them. And if they're still children, they can't come on the show if they have an open CPS case, or even if they're at home with their parent, or the parent may be reluctant to have their child come on a show, on social media where 1 billion people will see you and hear you. A lot of people like their privacy. There are some situations where I represent children who were in CPS. I didn't represent them in the CPS case, but I'm representing them in lawsuits suing CPS. Okay, Justice says, get an expert, exclamation point. Yes, yes, yes. Talk to your attorney about getting an expert to help you in your CPS case. There are all types of experts, by the way. An expert testimony can be persuasive and influential in your CPS court hearing, in your CPS court trial, and with the social worker. All right, no more questions for today. I want to thank everyone. We'll see you tomorrow, sometime tomorrow, on our office hours. It won't be at 6:30 because I unless I can do the show from the car, I may be driving up to the court location with someone, and maybe I can do it from my iPhone, and maybe we can keep our streak going. One last question. Great seeing you, Mr. Davis. Margaret says, great seeing you, Mr. Davis. Thank you. Until next time. All right, folks. Everyone have a good Sunday. Stay safe, and we'll see you hopefully tomorrow on my office hours.
I went through 9 months of hell in trial, and Vince was fantastic in the courtroom. This is a trial attorney. This is someone that you just go and look pretty and sit there and let him do all the work. And we prevailed. 9 months of not knowing. But when you have Vincent W. Davis on your side, you feel comfortable and at ease because you know he's doing the best he can do for you. And I highly recommend him and his staff, because there was never a time where I couldn't call and say, I need help, or I'm feeling this way. I was always able to talk to someone. Now that I have my child back, God bless you, Vincent W. Davis.